Similar. I got upset with it.
Hammer gets-
They said there was no problem right now.
Hammer gets slaughtered.
I ended up telling.
This is your House Committee on Commerce and Economic Development. It is May 1st at 2:30 p.m. We are back from the floor and we are here now to go with a walkthrough of S71, an act relating to consumer data privacy and online surveillance. Rick, take it
Good
away.
afternoon. I would need a Zoom link. I don't think I have one for this portion, although maybe the original one works too. Let's try that. Sometimes it carries over.
Scary.
Zoom link's carry. It does. Look at this. Wow. Okay. Rick Sagel, Office of Legislative Counsel. So a little bit of background, so we're not totally confused what's going on. This morning, we walked through H208, which is the bill introduced in the House. And S71 was passed by the Senate. S71, as introduced in the Senate, was a companion bill to 208. So the two were identical, right? S71 was referred to Senate institutions where they decided to do a strike all of S71 and put in the contents of S93. S93 was a comparable data privacy bill introduced by a different member in the Senate. So even though the number is the same, S71, it is not a companion bill to H208. There are some differences. I also want to say that the bills are probably 90% the same, but that 10% is important, right? Some things are more important than other things, but and I'll try to highlight as much as I can those differences. I think, as you'll hear from witnesses, testimony, they'll point out their reasons that they do or don't like either of the bills, and you can decide. And of course, ask me if you want questions about the differences. So, sound good? Okay, I guess I should share my screen. So again, this is the as passed in the Senate version, S71. And you'll notice that it's got about 20 fewer pages, which is nice for me. I don't have to talk for quite as long, and nice for you. And a lot of those pages comes from the definition section. The definition section of H208, I think it had 60 something definitions. This bill 71 has 40 some definitions, so you're losing some definitions. Also, H208 has the study from the AG's office, and it has some applicability changes. Remember at the end where we go from 25,000 to 12,000, this does not do that. So you're losing some pages in this version compared to 208. Okay, so it's actually the same title. I did put it in the same chapter, so that's all the same. The numbers are pretty similar as far as the section numbers go, not always the same. We start in 2415, the definitions. We have a definition of abortion in this bill. We did not have that in H208. Abortion means terminating a pregnancy for any purpose other than producing a live birth. Affiliate, no change there to that definition. Authenticate, use reasonable means to determine that a request to exercise any of the rights afforded under 2418 A1 through 4, which we'll get to, is being made by or on behalf of the consumer who's entitled to exercise the rights with respect to the personal data at issue. Biometric data is in this bill. The definitions are a little bit different, so make sure you're aware of that. In this bill, it means personal data generated by automatic measurements of an individual's unique biological patterns or characteristics that are used to identify a specific individual. It does not include a digital or physical photograph, an audio or video recording, or any data generated from a digital or physical photograph, or an audio or video recording, unless such data is generated by or to identify a specific individual. We have business associate and child defined. 7A consent means a clear affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement to allow the processing of personal data relating to the consumer. It may include a written statement, including by electronic means, or any other unambiguous affirmative action. Does not include acceptance of a general or broad terms of use or similar document that contains descriptions of personal data processing along with other unrelated information, hovering over, muting, pausing, or closing a given piece of content or agreement obtained through use of dark patterns. I think that's the same. Don't hold me to it. It feels, I couldn't compare them all in the last hour and a half, but I feel those are pretty similar. Consumer is an individual who is a resident of the state and does not include a similar definition to what is an H208. Consumer health data means any personal data that a controller uses to identify a consumer's physical or mental health condition or diagnosis, including gender affirming health data and reproductive or sexual health data. Consumer health data controller means any controller that alone or joint with others determines the purpose and means of processing consumer health data. Controller is the same. COPA is the same. Covered entity is the same. Dark pattern is the same. I'm just going to save you all time. If you would like me to go over it again, I'd be glad to. The sentence definition is, I'll read it because I'm not sure if it's exactly the same word for word, means decisions made by the controller that result in the provision or denial by the controller of financial or lending services, housing, insurance, education, enrollment, or opportunity, criminal justice, employment opportunities, healthcare services, or access to essential goods or services. 16, de-identified data means data that does not identify and cannot reasonably be used to infer information about or otherwise be linked to an identified or an identifiable individual or a device linked to the individual if the controller that possesses the data takes reasonable measures to ensure that the data cannot be associated with an individual, publicly commits to process the data only in a de-identified fashion and not attempt to re-identify the data, and contractually obligates any recipients of the data to satisfy the criteria set forth in the previous two subdivisions. Gender affirming healthcare services is defined in 1 VSA 150. Gender affirming health data means any personal data concerning a past, present, or future effort made by a consumer to seek or a consumer's receipt of gender affirming healthcare services. Talked about geofencing. It is. Did the other one have the specific? Yeah, I get those that into. I don't want to do this every time, but just it does not. Okay, it's the same. HIPAA is the, you all know that one. Identified or identifiable individual means an individual who can be readily identified directly or indirectly. Institution of higher education means any individual who, or school, board, association, or limited liability company or corporation that is licensed or accredited to offer one or more programs of higher learning, leading to one or more degrees. Mr. Chair, please.
Yeah, leave it open.
That's all you get to do when you get promoted from door closer.
It's cooler outside, definitely. Yeah. 23, mental health facility means any healthcare facility in which at least 70% of healthcare services provided in the facility are mental health services.
Just stop.
Ah,
Yes.
yes. All right, back to it. I was gonna make that joke about the chair coming in, but I decided not to do that. Listening. Nonprofit organization means any organization that is qualified for tax exempt status.
Right.
Yeah, sorry.
That's okay. Any particular reason why nonprofits are not also included under the institutions of higher education?
So they're not inherently not included. School
I mean,
Board
does it
Association,
call
LLC, or corporation.
Is it
So-
LLC or
Yeah,
corporate?
It could be a nonprofit corporation, right?
Sure.
But that's something we could highlight, and in case that is an issue, maybe you have one of your witnesses that explains.
Well, I guess I'm wondering, is that a standing definition?
What do you mean?
Is institution of higher learning or higher education a standing definition in our statutes that's like specifically defined by those?
So if it is, it wouldn't matter. So we are defining it here this way, so we wouldn't look to other Vermont definitions of, what higher education is.
Okay.
So if you think that we should add nonprofit or that it should be clear that it includes nonprofits, I would encourage the committee to
I mean,
request that or at least take testimony to see if that's necessary.
oh, huge deal, but something fine.
So I'll say, I'll kind of spoil this, but nonprofits are exempt. In this-
Yeah, no,
in this bill.
right.
This not in H2A, but in S71, nonprofits are exempt. 20, talk about that, talk about nonprofit. And I'd also note that they're exempt if they meet this definition of nonprofit, if they're one of these categories. A person is anything, really. It could be individual, association. Personal data means any information that is linked or reasonably linkable to an identified or identifiable individual. It does not include de-identified or publicly available information. For some precise geolocation is not 1850, it's 1750. One thing I meant to mention, this bill is very similar to Connecticut's, right? So, there's going to be times where you'll note a difference between this and H208. A lot of times it's because Connecticut went with that number in this case. Doesn't mean you have to, but that's kind of the template that was used for S71.
Can I just clarify that both bills are based off Connecticut and that 208 was the result of our working committee, and we heard lots of testimony around geolocation, geofencing in particular, and 1850 is actually California. I will not normally interrupt, but they're both based on Connecticut.
I appreciate details you want to provide in my head. And I did say that the bills, are 90% similar, right? And there's this template, right, that we're not the first state to do this. So other states thankfully have taken this up. This is basically what originally passed Connecticut. Like, this is what this bill is. For good or bad, that's the way this is. And H208 did build upon that in ways that are maybe good or bad, depending on how you see it, right? Precise geolocation data does not include the content of communications, data generated by or connected to an advanced utility metering infrastructure system, or data generated by equipment used by a utility company. Process or processing means any operation or set of operations performed, whether by manual or automated means, on personal data or on sets of personal data, such as the collection, use, storage, disclosure, analysis, deletion, or modification of personal data. Processor is the same. Profiling means any form of automated processing performed on personal data to evaluate, analyze, or predict personal aspects related to an identified or identifiable individual's economic situation, health, personal preferences, interest, reliability, behavior, location, or movements. Protected health information has the same meaning as in HIPAA. Synonymous data is data that cannot be attributed to a specific individual without the use of additional information, provided that information is kept separately and is subject to appropriate technical and organizational measures to ensure that the personal data is not attributed to an identified or identifiable individual. 33, publicly available information means information that is lawfully made available through federal, state, or local government records or widely distributed media, or a controller has a reasonable basis to believe the consumer has lawfully made available to the general public. Reproductive or sexual healthcare means any healthcare related services or products rendered or provided concerning a consumer's reproductive system or sexual well-being, including any such service or product rendered or provided concerning an individual health condition, status, disease, diagnosis, diagnosis, test, or treatment, a social, psychological, behavioral, or medical intervention, a surgery or procedure, including an abortion, a use or purchase of a medication, including a medication used or purchased for the purposes of an abortion, a bodily function, vital sign, or symptom, a measurement of a bodily function, vital sign, or symptom, or an abortion, including medical or non-medical services, products, diagnostics, counseling, or follow-up services for an abortion. Reproductive or sexual health data means any personal data concerning an effort made by a consumer to seek or a consumer's receipt of reproductive sexual health care. Reproductive or sexual health facility means any healthcare facility in which at least 70% of the healthcare Related services or products rendered or provided in the facility are reproductive or sexual health care. 37A, sale of personal data means the exchange of a consumer's personal data by the controller to a third party for monetary or other valuable consideration. It does not include the disclosure of personal data to a processor that processes the personal data on behalf of a controller. The disclosure of personal data to a third party for purposes of providing a product or service requested by the consumer. The disclosure or transfer of personal data to an affiliate of the controller. The disclosure of personal data where the consumer directs the controller to disclose the personal data or intentionally uses the controller to interact with a third party. Disclosure of personal data that the consumer potentially made available to the general public via channel mass media and did not restrict to a specific audience. Or the disclosure, this is again what it does not include, the disclosure or transfer of personal data to a third party as an asset that is part of a merger, acquisition, bankruptcy, or the transaction, or a proposed one of those in which the third party assumes control of all or part of the controller's assets. Sensitive data means personal data that includes data revealing racial or ethnic origin, religious beliefs, mental or physical health condition, or diagnosis, sex life, sexual orientation, or citizenship or immigration status. Consumer health data, the processing of genetic or biometric data for the purpose of uniquely identifying an individual. Personal data collected from a known child. Data concerning an individual's status as a victim of a crime. And an individual's precise geolocation data. Targeted advertising means displaying an advertisement to a consumer where the ad is selected based on personal data obtained or inferred from that consumer's activities over time and across non-affiliated websites or online applications to predict the consumer's preferences or interests. It does not include an ad based on activities within the controller's own commonly branded website or online application, an ad based on the context of a consumer's current search query, visit to a website, or use of an online application, an ad directed to a consumer in response to the consumer's request for information or feedback, or processing personal data solely to measure or report advertising frequency, performance, or reach. And then third party and trade secret are similar to H208. Questions about the definitions? Okay. Applicability. I will not skip it this time. Except as provided later, this chapter applies to a person that conducts business in the state or a person that produces products or services that are targeted to residents of the state and during the preceding year. So that language is similar to H208. However, the thresholds are different. Or process the personal data of not fewer than 100,000 consumers, excluding personal data to process solely for the purpose of completing the payment transaction. Remember, in H208, it was 25,000. Or control to process the personal data of not fewer than 25,000 consumers and derive more than 25% of the person's gross revenue from the sale of personal data. H208, it was 12,500, right?
Persons are, do we have a different definition for persons for this? Or is it the same definition that's in
This is, so you're talking about,
up above, you said persons, right?
so person is like any entity, could be an individual, could be a corporation, could be a, yep. That is defined here. We didn't have to do it, but it is defined.
But in the consumer protection bill, person is
Right.
everybody for businesses.
Right. Unless they're exempt, right? So they may be exempt, but. So section 2426, which is the consumer health data portion, shall apply to a person that conducts business in the state or a person that produces or produces products or services that are targeted. That is similar to H208. The exemptions. So if you're going to look at anything for homework after I'm done with this, I want you to compare the exemptions because they are complex. Some are, you may have heard entity level exemptions, right? So an entity level exemption means that entire entity is exempt from the law, okay? Sometimes you'll hear a data level exemption. And when it's a data level exemption, that means that it's, a very specific exemption. The entity is not exempt, but data that pertains to that entity in regards to how it's written in the bill may be exempt, if that makes sense. So it's going to be hard for me to explain the differences between both of the bills, but something you can look at on your own time. So except as provided in subsection C, this chapter shall not apply to any body, authority, board, bureau, commission, district, or agency of this state or any political subdivision. That's similar to the state local government exemption, but as Rep. Olson notated, there's that little in H208, there's a little in the ordinary course of business, right, or whatever the language was in H208. That is not here. The tribal exemption is later, but so yeah, you basically exempt state local governments from this bill. Also, a person who has entered into a contract with an entity described in subdivision 1. So if you are working on behalf of a government to process consumer health data. So nonprofits, if you are a nonprofit and you meet the definition of nonprofit as we defined it in this bill, you are exempt from the bill. If you're an institution of higher education, a national securities association, I would defer to my colleague Maria Royal on who that may include, or I'm sure we get testimony on who this does and does not include.
Is that supposed to be 780? Or is that supposed to be a 0 on line 18?
I will double check. It's been through editing, but sometimes things get missed. Federal law is weird, right?
It is.
Things are codified in several places. Sometimes you have like yeah. So I will check that. Page 12. Okay, page 13. Financial institution or data subject to Title V of the Graham-Leach-Bliley Act and regulations adopted to implement that act. Covered entity or business associate, tribal nation government organization. So there's your separate exemption for that. The air carriers, again, not too ready for information about what this exempts, but you have some federal acts that have requested some federal laws that are needing to be exempted for various reasons. B, the following information, data, and activities are exempt. Okay, so notice subsection A was shall not apply to any. And subsection B, the leading languages, information, data, and activities are exempt. Protected health information, patient identifying information. Again, you're looking at federal medical research. Let's skip these. These are very similar to what's in the H208.
I wonder if the air thing has something to do with the fact that it's, air travel and maybe like a terror list or something.
Passports.
Yeah. Sorry.
Yeah, I don't know. I don't know. 10, the collection, maintenance, disclosure, sale, communication, or use of any personal information bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living by a consumer reporting agency, furnisher or user that provides information for use in a consumer report, and by a user of a consumer report, but only to the extent that such activity is regulated by and authorized under the Fair Credit Reporting Act, as may be amended. Personal data collected, processed, sold, or disclosed under and in compliance with the Driver's Privacy Protection Act of '94 and the Farm Credit Act. Personal data regulated by FERPA, as may be amended. Data processed or maintained in the course of an individual applying to, employed by, or acting as an agent of an independent contractor of a controller, processor, consumer health data controller, or third party, to the extent that the data is collected and used within the context of that role. As the emergency contact information of a consumer pursuant to this chapter used for emergency contact purposes, or that is necessary to retain to administer benefits for another individual relating to the individual who is the subject of the information pursuant to subdivision 1 of B1. That's what this is here. HIPAA, okay. And then we have personal data collected, processed, sold, or disclosed in relation to price, route, or service as such terms that are used in the Federal Aviation Act of 1958. So, again, these are negotiated behind the scenes. I don't know the details of the negotiations. Subsection C, controllers, processors, and consumer health data controllers that comply with the verifiable parental consent requirements of COPA shall be deemed compliant with any obligation to obtain parental consent pursuant to this chapter. 2418, consumer rights, complied by controllers and appeals. A consumer shall have the right to, 1, confirm whether or not a controller is processing the consumer's personal data and access to personal data, unless the confirmation is or access will require the controller to reveal a trade secret. Correct inaccuracies in the consumer's personal data, taking into account the nature of the personal data and the purposes of the processing of the consumer's personal data. Delete personal data provided by or obtained about the consumer. Obtain a copy of the consumer's personal data processed by the controller in a portable and, to the extent technically feasible, readily usable format. That allows the consumer to transmit the data to another controller without hindrance, where the processing is carried out by automated means, provided the controller shall not be required to reveal any trade secret. And 5, opt out of the processing of the personal data for purposes of targeted advertising, the sale of personal data, except as provided in 2420B, we'll get to, or profiling in furtherance of solely automated decisions that produce legal or similarly significant effects concerning the consumer. I believe in H208 there were 7 or 8 of these. So again, you know, when at some point we can compare them, but there are different rights that consumers have under the different bills. B1, a consumer may exercise rights under the section by a secure and reliable means established by the controller and described to the consumer in the controller's privacy notice. A consumer may designate an authorized agent in accordance with section 2419 to exercise the rights of the consumer to opt out of the processing of their personal data. In the case of processing personal data of a known child, the parent or legal guardian may exercise the consumer rights on the child's behalf. In the case of processing personal data concerning a consumer subject to guardianship, conservatorship, or other protective arrangement, the guardian or the conservator of the consumer may exercise the rights on the consumer's behalf. C, except as otherwise provided in the chapter, a controller shall comply with a request by a consumer to exercise the consumer rights authorized pursuant to this chapter as follows. The controller shall respond to the consumer without undue delay, but not later than 45 days after receipt. The controller may extend the response by 45 additional days. This should look similar. They're pretty similar. If the controller declines to take action regarding the consumer's request, the controller shall inform the consumer without undue delay, but not later than 45 days after, how to appeal. Information provided in response to a consumer request shall be provided by a controller free of charge once per consumer during a 12-month period. If requests from a consumer are manifestly unfounded, excessive, or repetitive, the controller may charge the consumer a reasonable fee to cover the costs of complying with the request or decline. The controller bears the burden of demonstrating the manifestly unfounded, excessive, or repetitive nature of the request. If a controller is unable to authenticate a request to exercise any of the rights between A1 and 4 of this section, the controller shall not be required to comply with a request to initiate an action pursuant to the section and shall provide notice to the consumer that the controller is unable to authenticate the request to exercise the right or rights until the consumer provides additional information reasonably necessary to authenticate the consumer and the consumer's request to exercise the right or rights. Yeah.
Sorry, I'm struggling with this part that you just.
Mhm.
Talk me through that in a little less legalese and a little more.
Sure. So a consumer has a set of rights, right? They can request to opt out. They can request to, I'll go through A1 through 4 again. they can request to confirm whether or not a controller is processing the personal data. They have the right to correct inaccuracies in the personal data. They have the right to have their personal data deleted, and to obtain a copy of personal data, and then 5 opt out. So what happens is the controller gives the consumer the right to do these things, and the controller has this 45-day window, right, to act. And there's an exception if they need more time based on the type of request. If they decline to do what the consumer wants, they have to justify what that reason. And the consumer will have a right to appeal. Talk about it in a second. If the information is
It was B that you just scrolled past that kind of, you just passed, go back down.
go back down. This one here,
Nope, after that.
this here.
If requests from a consumer are manifestly unfounded, excessive, or repetitive, the controller may charge the consumer a reasonable, so what? How could that play out in the real world? Can you?
Yeah, so I will also say this is similar to H208. I'll say that. I don't know how that would play in the real world. I imagine there'd be communication between the consumer or their agent and the controller, and they would say, "Look, we have 45 days to do this. However, we believe this request is whatever manifestly unfounded, excessive, or repetitive. In order to do this, we would have to charge you a fee."
So it's a protection for businesses that might be feeling or having, I guess, an overwhelming.
Right.
Okay.
Right.
Just wanted to make sure I was reading it the way that.
Yeah.
That it was. Thank you.
Yeah, you can imagine someone spamming a controller, and then the law gives them a way to not have to respond to those requests in 45 days or not respond at all, right? C, the controller does bear the burden of demonstrating the manifestly unfounded, excessive, whatever nature of the request. Let's see. I think we were skip down to B. A controller shall not be required to authenticate an opt-out request, but a controller may deny an opt-out request if the controller has a good faith, reasonable, and documented belief that the request is fraudulent. If they deny an opt-out request because they believe it's fraudulent, they shall send a notice to the person who made the request, disclosing that they believe the request is fraudulent, why they believe it's fraudulent, and that they shall not comply with it. A controller that has obtained personal data about a consumer from a source other than the consumer shall be deemed in compliance with a consumer's request to delete the data pursuant to A3, which is the deletion right, by retaining a record of the deletion request and the minimum data necessary for the purpose of ensuring the consumer's personal data remains deleted from the controller's records and not using the retained data for any other purpose pursuant to the provisions of the chapter, or opting the consumer out of the processing of the personal data for any purpose except for those exempted pursuant to the provisions of this chapter. D1, a controller, top of page 21, a controller shall establish a process for a consumer to appeal their refusal to take action on a request within a reasonable period of time after the consumer's receipt of the decision. The appeal process shall be conspicuously available and similar to the process for submitting a request to initiate action. Not later than 60 days after receipt of an appeal, a controller shall inform the consumer in writing of any action taken or not taken in response to the appeal, including a written explanation of the reasons for the decisions. If the appeal is denied, the controller shall also provide the consumer with an online mechanism, if available, or other method through which the consumer may contact the AG. So these are pretty similar. The appeals process for H208 and S71. 2419. Yeah.
The Senate, do any kind of comparison or take testimony on where things were comporting between the two bills?
So I did give a walkthrough of the difference between the two.
Mhm. Okay.
2419, authorized agents and consumer opt-out. A consumer may designate another person to serve as the consumer's authorized agent and act on the consumer's behalf to opt out of the processing of the consumer's personal data. 208 combines this in their section 2418. This bill had it separately. It's fine. They both do the same thing. The consumer may designate an authorized agent by way of, among other things, a technology, including an internet link or browser setting, browser extension, or global device setting. A controller shall comply with an opt-out request received from an authorized agent if the controller is able to verify with commercially reasonable effort the identity of the consumer and the authorized agent's authority to act on the consumer's behalf. Okay, 2420, consumers' duties, sale of data to third parties, notice and disclosure to consumers, consumer opt-out. So, a controller shall limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to the purposes for which the data is processed as disclosed to the consumer, except as otherwise provided in the chapter, shall not process personal data for purposes that are neither reasonably necessary to nor compatible with the disclosed purposes for which the personal data is processed as disclosed to the consumer, unless the controller obtains the consumer's consent. Shall establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data appropriate to the volume and nature of the data at issue. Shall not process sensitive data concerning a consumer without obtaining the consumer's consent, or in the case of processing sensitive data concerning a known child, without processing the data in accordance with COPPA. So that's a pretty important difference, right? I'm not pointing out all the differences, but that is one where in H208, you just don't process personal data, sensitive data. And then here, or of minors, here it defers to COPPA. And I think I mentioned this during the 208 walkthrough, that 208 goes a bit further than what COPPA does, which I'm not sure if that's going to be printed or not, but it is something to think about. Here, it's the requirements are to be within COPPA. Just want to point that out. Subdivision 5.
How does that work if they're not subject to COPPA?
If the business is not, if the entity is not. So if they are not regulated by COPPA, I'm trying to think because we're comparing. The bill says without processing data in accordance with COPPA. I would need to check that and see if you, when you reference a federal law, if an entity is not subject to that law, but we're saying if you were subject and you had to process, I don't know. It's a good question.
I was just gonna say, it's COPA in both bills, like in this one, it's 13 years of age. I just want to point out to everybody in case they're not thinking about the age ranges.
Yeah, but I think we talked last year when we were looking at what healthcare fields do. They're under HIPAA. There are areas that they also have data that's not covered under HIPAA. And we talked about language that would say that so long as they covered that language, so long as they covered that data as if it were HIPAA data, then they were okay. But I think everybody had heartburn with that, so I'm just wondering how this would work.
Yeah, I will get back to you. I don't know off the top of my head, but it's a interesting question. Okay, moving on to 5. Shall not process personal data in violation of the laws of the state and federal laws that prohibit unlawful discrimination against consumers. and these are controllers, what a controller shall do or shall not do, shall provide an effective mechanism for a consumer to revoke the consent under the section that is at least as easy as the mechanism that they gave to give consent, and upon revocation of consent, cease to process the data as soon as practicable, but not later than 15 days after receipt of the request. Shall not process the personal data of a consumer for purposes of targeted ads or sell their data without consumers' consent under circumstances where a controller has actual knowledge and willfully disregards that consumer is at least 13 of age but younger than 16 of age.
How difficult is to prove willfully disregarding something?
It's pretty high standard, right? There would need to be proof that they were aware that, they had these users or consumers, minor consumers, that they had this data and they were processing for targeted ads. There would need to be proof that they knew that they had this and they were doing it and they still did it, which would come out, in discovery in a court action, but it's a high standard. Yeah. 8, shall not discriminate against the consumer for exercising any of the consumer rights contained in the chapter, including denying goods or services, charging different prices or rates for goods or services, or providing a different level of quality of goods or services to the consumer. Subsection A, which we just covered, shall not be construed to require a controller to provide a product or service that requires the personal data of a consumer that the controller does not collect or maintain, or prohibit a controller from offering a different price, rate, level, quality, or selection of goods or services to a consumer, including offering goods or services for no fee if the offering is in connection with a consumer's voluntary participation in a bona fide loyalty, rewards, premium features, discounts, or club card program. Okay, C is the privacy notice. Bless you. I did not go through the privacy notice in 208. I can go through it here. There are some differences. Let me just go ahead and go through this. So C on page 24. A controller shall provide consumers with a reasonably accessible, clear, and meaningful privacy notice that includes the categories of personal data processed by the controller, the purpose for processing the personal data, how consumers may exercise their consumer rights, including how consumer may appeal at the controller's decision with regard to consumer's request, the categories of personal data that a controller shares with a third party, if any, the categories of third parties, if any, with which the controller shares personal data, and an active email address or other online mechanism that the consumer may use to contact the controller. If a controller sells personal data to third parties or processes personal data for targeted advertising, the controller shall clearly and conspicuously disclose the processing as well as the manner in which a consumer may exercise the right to opt out of the processing. E1, a controller shall establish and shall describe in a privacy notice one or more secure and reliable means for consumers to submit a request to exercise their rights pursuant to the chapter. The means shall take into account the ways in which consumers normally interact with the controller, the need for secure and reliable communication of the requests, and the ability of the controller to verify the identity of the consumer making the request. A controller shall not require a consumer to create a new account, but may require consumer use of an existing account. The means shall include providing a clear and conspicuous link on the controller's website to a web page that enables the consumer or agent to opt out of the targeted ads or sale of their data. Not later than Jan 1, 2026, allowing a consumer to opt out. This we need to look at because the bill is effective July 1st, 2026. So let me look at that. We can either change that to July 1st, 2026 or have a different date, but we need to change it. Not later than January 1st, 2026, allowing a consumer to opt out of any processing of the consumer's personal data for the purposes of targeted advertising or sale of any personal data through an opt-out preference signal sent to the controller with the consumer's consent, indicating the consumer's intent to opt out of the processing or sale by a platform, technology, or other mechanism that shall, one, not unfairly disadvantage another controller, not make use of a default setting, but rather require the consumer to make an affirmative, freely given, and unambiguous choice to opt out of any processing of their personal data. Be consumer friendly and easy to use by the average consumer. Be as consistent as possible with any other similar platform technology and mechanism required by any federal, state, law or regulation. And enable the controller to accurately determine whether the consumer is a resident of the state and whether the consumer has made a legitimate request to opt out of any sale of the consumer's personal data or targeted advertising. B, if a consumer's decision to opt out of any processing of the consumer's personal data for purposes of targeted advertising or any sale of the personal data through an opt-out preference sent in accordance with this law, conflicts with the consumer's existing controller-specific privacy setting. This is similar, right? The controller shall comply with the consumer's opt-out preference signal, but may notify the consumer of the conflict and provide the consumer the choice to confirm their setting or participation in the program. If a controller responds to a consumer opt-out request received by informing the consumer of a charge for the use of any product or service, the controller shall present the terms of any financial incentive offered pursuant to subsection B of the section for the retention, use, sale, or sharing of the consumer's personal data. Questions about controllers' duties? Okay, 2421. Processors' duties, contracts between controllers and processors. A processor shall adhere to the instructions of the controller and shall assist the controller in meeting the controller's obligations of the chapter, including taking into account the nature of processing and the information available to the processor by appropriate technical and organizational measures, and to the extent reasonably practicable, to fulfill the controller's obligation to respond to consumer rights requests. Taking into account the nature of processing and the information available to the processor by assisting the controller in meeting the controller's obligations in relation to the security of processing the personal data and in relation to the notification of a data broker security breach or security breach, as defined in section 2430, of the system of the processor in order to meet the controller's obligations, and providing necessary information to enable the controller to conduct and document data protection assessments. A contract between a controller and processor shall govern the processor's data processing procedures with respect to processing performed on behalf of the controller. The contract shall be binding and clearly set forth instructions for processing data, the nature and purpose of processing, the type of data subject to processing, the duration of processing, and the rights and obligations of both parties. The contract shall require the processor ensure that each person processing personal data is subject to a duty of confidentiality with respect to the data. At the controller's direction, delete or return all personal data to the controller as requested at the end of the provision of services, unless retention is required by law. Upon the reasonable request of the controller, make available to the controller all information in its possession necessary to demonstrate the processor's compliance with the obligations in the chapter. After providing the controller an opportunity to object, engage any subcontractor pursuant to a written contract that requires a subcontractor to meet the obligations of the processor with respect to the personal data, and make available to the controller upon the reasonable request of the controller all information in the processor's possession necessary to demonstrate the processor's compliance with the chapter. 4, a processor shall provide a report of an assessment to the controller upon request. The section shall not be construed to relieve a controller or a processor from liabilities imposed on the controller or processor by virtue of the controller or processor's role in the processing relationship as described in this chapter. Determining whether a person is acting as a controller or processor with respect to a specific processing of data is a fact-based determination that depends on context. A person who is not limited in the person's processing of personal data pursuant to a controller's instructions, or who fails to adhere to the instructions, is a controller and not a processor with respect to a specific process of data. A processor that continues to adhere to a controller's instructions with respect to a specific process in a personal data remains a processor. If a processor begins alone or joined with others, determining the purposes and means of the processing of personal data, the processor is a controller with respect to the processing and may be subject to an enforcement action under section 2425 of the title. 2422. Controller's data protection assessments, disclosure to the Attorney General. A controller shall conduct and document a data protection assessment for each of the controller's process and activities that presents a heightened risk of harm, which means or includes the processing of personal data for the purposes of targeted ads, the sale of personal data, the processing of personal data for the purpose of profiling, where profiling presents a reasonably foreseeable risk of unfair or deceptive treatment or unlawful desperate impact on the consumers, financial, physical, or reputational injury to consumers, a physical or other intrusion upon the solitude or seclusion or the private affairs or concerns of consumers, where the intrusion would be offensive to a reasonable person.
No, sorry.
Oh, okay.
I was pointing towards Cooper.
Oh.
He obviously didn't get my text message.
Okay.
Thank you.
Or other substantial injury to consumers, and the processing of sensitive data. B1, data protection assessments conducted shall identify and weigh the benefits that may flow directly and indirectly from the processing to the controller, the consumer, other stakeholders, and the public against the potential risks to the rights of the consumer associated with the processing, as mitigated by safeguards that can be employed by the controller to reduce the risks. The controller shall factor into any data protection assessment the use of de-identified data and the reasonable expectations of consumers, as well as the context of the processing and the relationship between the controller and the consumer whose personal data will be processed. The AG may require that a controller disclose any data protection assessments that is relevant to an investigation. This is similar. The AG may evaluate the data protection assessment for compliance with the responsibilities set forth in this chapter. They are confidential, exempt from disclosure under the PRA, Public Records Act, not private right of action. That used to be the PRA, Public Records Act. To the extent any information contained in a data protection assessment includes attorney-client privilege or work product protection, that is not a waiver of that privilege. A single assessment may address a comparable set of process and operations. If they make one of these assessments for another law, it can work for the Vermont law as well, as long as it's similar in scope and covers what's in this chapter. Data protection assessments requirement shall apply to processing activities created or generated after July 1st, 2025 and are not retroactive. We may also want that to be 2026.
I'm confused.
Okay.
I guess, well, between this and 208, how does this like functionally differ between 208?
That's a big question.
Okay, I'm sorry for having.
No, that's not a bad question.
Yeah, I think we'll get through the language
Okay.
and we'll schedule another meeting, another hearing to actually understand what the differences are between the two. That'd be good.
Yeah, because one word can make such a big difference, and I don't have all the words in my head. I don't know the differences right now. So I did at one point. I did, but it's been several months or days since that last. Yeah. So yeah, yes, good question. But
just like it's very good.
Yeah. 24, and like I think we need to probably address this date since it's effective July 1st, 2026. 2423. De-identified and pseudonymous data, controllers' duties, exceptions, applicability of consumers' rights, disclosure, and oversight. A controller in possession of de-identified data shall take reasonable measures to ensure the data cannot be associated with an individual. 2, publicly commit to maintaining and using de-identified data without attempting to re-identify the data. And 3, contractually obligate any recipients of the de-identified data to comply with the provisions of the chapter. The chapter shall not be construed to require a controller or processor to re-identify de-identified data or pseudonymous data, or maintain data in an identifiable form or collect, obtain, retain, or access any data or technology in order to be capable of associating an authenticated consumer request with personal data. I wonder if we need some language here about, sorry, I'm kind of thinking as I walk through this chapter should not be construed to require a controller or processor to do this thing, but we don't have intro language for this one. So I'm wondering if we need to like who has to maintain the data or who does not have to, yeah. Maybe I'm overthinking it. Subsection C, but I'm going to note that just in case. So page 2033. 2. Okay, C, the chapter shall not be construed to require a controller or processor to comply with an authenticated consumer rights request if the controller, 1, is not reasonably capable of associating the request with the personal data, or it would be unreasonably burdensome for the controller to associate the request with the personal data. 2, does not use the personal data to recognize or respond to the specific consumer who is the subject of the personal data, or associate the personal data with other personal data about the same specific consumer. And 3, does not sell the personal data to any third party or otherwise voluntarily disclose the personal data to any third party other than a processor, except as otherwise permitted in the section. The rights afforded, these are the consumer rights, A1, 2418, A1 through 4, the right to delete data, know what data they have, shall not apply to pseudonymous data in cases where the controller is able to demonstrate that any information necessary to identify the consumer is kept separately and is subject to effective technical and organizational controls that prevent the controller from accessing the information. A controller that discloses pseudonymous data or de-identified data shall exercise reasonable oversight to monitor compliance with any contractual commitments to which the pseudonymous data or de-identified data is subject and shall take appropriate steps to address any breaches of those contractual commitments. Construction of controllers and processors' duties, limitations. This chapter shall not be construed to restrict a controller's, processor's, or consumer health data controller's ability to comply with federal, state, municipal ordinances or regulations, comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons by a federal, state, municipal, or other governmental authority, cooperate with law enforcement concerning conduct or activity that the controller, processor, or consumer health data controller reasonably and in good faith believes may violate federal, state law, investigate, establish, exercise, prepare for, defend legal claims, provide a product or service specifically requested by the consumer.
Can you just go back up to 3? No, 2, I think. Maybe. So in 3, it's law enforcement brings them, goes to them with a concern.
Cooperate with law enforcement. So it doesn't say, it could be that they come to the controller, or it could be that the controller.
Or would it be the controller also would have to notify law enforcement if they believe that there's a violation?
There's no burden there's no action required of the controller to notify law enforcement. Is that the question? It's saying that the law's restrictions on processing of personal data does not affect the ability to cooperate with law enforcement when it comes to requesting probably certain information that they believe. And now there's this in good faith belief, may violate. There's some kind of law been violated, so the controller does have that requirement that they must in good faith believe that something's gone wrong, and they have information that might help law enforcement. Yeah.
Okay.
5, provide a product or service specifically requested by a consumer. 6, perform under a contract to which a consumer is a party, including terms of written warranty. 7, take steps at the request of a consumer prior to entering into a contract. Take immediate steps to protect an interest that is essential for life or physical safety of the consumer or another individual, and where the processing cannot be manifestly based on an illegal basis. Prevent, detect, protect against, or respond to security incidents, identity theft, fraud, harassment, malicious or deceptive activities, or any illegal activity. Preserve the integrity or security of systems, or investigate, report, or prosecute those responsible for the action. 10, engage in public or peer-reviewed scientific or statistical research in the public interest that adheres to all other applicable ethics and privacy laws and is approved, monitored, and governed by an institutional review board that determines, or similar independent oversight entities that determine, A, whether the deletion of the information is likely to provide substantial benefits that do not exclusively accrue to the controller. B, that the expected benefits of the research outweigh the privacy risks. And C, whether the controller or consumer health data controller has implemented reasonable safeguards to mitigate privacy risks associated with research, including any risks associated with re-identification. 11, assist another controller, processor, consumer health data controller, or third party with any of the obligations under this chapter, or process personal data for reasons of public interest in the area of public health, community health, population health, but solely to the extent that the processing is A, subject to suitable and specific measures to safeguard the rights of the consumer whose personal data is being processed, and under the responsibility of a professional subject to confidentiality obligations under federal, state, or local law. The obligations imposed on controllers, processors, or consumer health data controllers under this chapter shall not restrict a controller, processor, or controller health data controller's ability to collect, use, or retain data for internal use, to conduct internal research, to develop and improve their products, to effectuate a product recall. 3, identify and repair technical errors that impair existing or intended functionality. Or 4, perform internal operations that are reasonably aligned with the expectations of the consumer or reasonably anticipated based on the consumer's existing relationship with the controller or consumer health data controller, or are otherwise compatible with processing data in furtherance of the provision of a product or service specifically requested by a consumer or the performance of a contract to which the consumer is a party. C1, the obligations imposed on controllers, processors, on consumer health data controllers under this chapter shall not apply where compliance by the controller, processor, or consumer health data controller with this chapter would violate an evidentiary privilege under laws of the state. The chapter shall not be construed to prevent a controller, processor, or consumer health data controller from providing personal data concerning a consumer to a person covered by an evidentiary privilege under laws of this state as part of a privileged communication. D1, a controller, processor, or consumer health data controller that discloses personal data to a processor or third-party controller pursuant to this chapter shall not be deemed to have violated this chapter if the processor or third-party controller that receives and processes the personal data violates this chapter, provided that at the time they disclose the data, did not have actual knowledge that the receiving processor or controller would violate the chapter. A third-party controller or processor receiving personal data from a controller, processor, or consumer health data controller in compliance with the chapter is not in violation of this chapter for the transgressions of the controller, processor, or consumer health data controller from which the third-party controller or processor receives the personal data.
Can I ask a question about that?
Yeah.
Feels like saying that are a bad actor, controller, and you open up another business and transfer all of the data to that other business, you're no longer responsible for what happened in the first business. Am I reading into that?
So it's again, I'll say the two bills are similar when it comes to this, but You're saying that if there is a controller, a bad actor, right, that creates another company,
Violating on purpose.
right?
Disregarding the law.
Wouldn't they know though that what they're doing is wrong and they would not be have the safe harbor as maybe we should put it, that they would, because this is protecting a controller that didn't know that this third party, quote unquote, would have violated the chapter. If you own this company,
Receiving personal data from a controller is not in violation for the transgressions of the controller from which the third party controller received the personal data.
so I think, yeah,
Just a question.
yeah, no, I'm thinking about it. So this D2 falls upon D1, and D1 says, that a controller that didn't have actual knowledge that a third party would have violated the chapter, right, is not responsible. However, D2 says that this third party that is innocent, which I think it works both ways, right? The third party, which is owned in your hypothetical by the controller, would know, right, that this is being done to obfuscate.
Or,
Yeah,
one of these somehow related organizations.
right.
Okay, we can go on. It just struck me and we can look at that further.
Sure, I'll note it here.
We go forward. Thank you.
Of course. Subsection E, this chapter shall not be construed to impose any obligation on a controller or processor that adversely affects the rights or freedoms of any person. This is similar to H208. 2 shall not be construed to apply to any person's, top of page 39, any person's processing of personal data in the course of a person's purely personal or household activities. Require an independent school as defined in our statutes or as a private institution of higher learning, higher education, which we reference federal law here, but we also have this term defined. Think about that. To delete personal data or opt out of processing of personal data that would unreasonably interfere with the provision of education services by that's an oops too. What was the Senate doing? I wrote it. So I gotta look and see what I missed there. Okay. So we're looking at G3, two things here. Okay. No matter what you do, there will be an amendment to the Senate proposal because there's some typos here. F1, personal data processed by a controller or consumer health data controller pursuant to this section. I normally bring you perfect legislation, but sometimes ignore the UCC bill, ignore the. Oh, can I make one side comment on another bill, H243, the David Hall bill? So the governor's office got it, and they found a mistake. But I don't take, so they noticed that. I'm not going to do this.
This is the secretary.
This is Title 11C.
Yeah.
So normally, Herb, you'll appreciate this. We call things Chapter 1, Chapter 2, right? In Title 11C, we call them Article 1, Article 2.
Oh,
So the green books are correct. The website is incorrect, and the way I import our language was incorrect. So I'm sort of to blame, but I'm also sort of not to blame.
It was my
reelection
campaign.
But they somehow they caught that. It's amazing. I can't believe they caught that. It's been fixed, so no worries. All right, back to data privacy.
These are
I got like a emergency email last night with a little red exclamation point from the governor's office. They're like, "This is a okay.
Oh, geez.
This is above my pay grade." F1, personal data that processed by a controller or consumer health data controller pursuant to the section may be processed to the extent that the processing is A, reasonably necessary and proportionate to the purposes listed in the section, and B, adequate, relevant, and limited to what is necessary in relation to the specific purposes listed in the section. 2A, personal data collected, used, or retained pursuant to subsection B shall, where appropriate, take into account the nature and purpose or purposes of the collection, use, or retention. The data shall be subject to reasonable administrative, technical, and physical measures to protect the confidentiality, integrity, and accessibility of the personal data and to reduce reasonably foreseeable risks of harm to consumers relating to the collection, use, or retention of personal data. G, if a controller or consumer health data controller processes personal data pursuant to an exemption in the section, the controller or consumer health data controller bears the burden of demonstrating that the processing qualifies for the exemption and complies with the requirements in subsection F. Processing personal data for the purposes expressly identified in the section shall not solely make a legal entity a controller or consumer health data controller for that with respect to the processing. Okay, 2425, enforcement by the AG, notice of violation, cure period, and report penalty. The AG shall have the exclusive authority to enforce violations of this chapter. This also needs to be adjusted here. During the period beginning on July 1st, 2025 and ending on December 31st, 2026, the AG shall, prior to initiating any action for a violation of any provision of this chapter, issue a notice of violation to the controller or consumer health data controller if the AG determines that a cure is possible. So I'll note this because I remember it. 208, it's a may, right? For the cure, this is a shall. If a controller or consumer health data controller fails to cure the violation within 60 days after receipt of the notice of violation, the AG may bring an action pursuant to the section. This is similar. Annually or on or before Feb 1st, the AG shall submit a report to the Assembly disclosing the number of violations, the nature of the violation, the number of violations that were cured, and any other matter the AG deems relevant. Beginning January 1st, 2027, the AG may, in determining whether to grant a controller or processor the opportunity to cure an alleged violation, consider the number of violations, the size and complexity of the controller processor, the nature and extent of their activities, the likelihood of injury to the public, the safety of persons or property, whether the alleged violation was likely caused by a human or technical error, and the sensitivity of the data. D, the chapter shall not be construed as providing the basis for or be subject to the private right of action for violations of this chapter or any other law.
Just when you go over DEF, Rick, I'm just wondering if you can not only go over the language, but go over the effect that this actually has.
As far as their ability to bring
Their access to their rights under the Consumer Protection Act.
Oh, so the consumer. Okay, sure. So of course, D makes it very clear that it is the AG's sole authority to enforce the law. Consumers would not have a private right of action. E, subject to the exception in subsection F, a violation of the requirements of this chapter shall constitute an unfair and deceptive act in commerce in violation of 2453 and shall be enforced solely by the AG, provided the consumer private right of action shall not apply. So again, making it very clear that while we're calling in the Vermont Consumer Protection Act, which does have that private right of action, this bill says there's not a private right. It would just be the AG.
Did the Senate take testimony from the AG about this?
So most testimony was over S71 as introduced, which was H208. So they did testify as to that language. And I think generally, I won't speak for the AG's office, but I think generally speaking, they're in favor of a private right of action, as long as they can also enforce, right? They like that ability as well. Yeah. But I'll let the AG speak for themselves.
Along those same lines, do you know if the Senate took testimony after they did the strike all, replacing what was the original 71, which matched our 208, and replaced it with this language, which is S93? Other than you.
Right. So so we did a strike all, and I did the as I mentioned, I did the comparison. I was actually, so I'm finding some errors because I never actually walked through the bill. And I think I would have caught some of these if I had read it in committee. Even though things sometimes get missed when I write it, when the editors miss it. So it was my testimony. just the comparison between the two. And by the way, I said on the record that that was a mistake, and I'll admit to it here too. I thought it was a mistake that they didn't take more testimony.
So you only did the overview of the walkthrough of the changes, which is like a side-by-side document, and not a full walkthrough of the language, nor were there additional witnesses, it sounds like.
That's my understanding. Yeah, because they voted it out after I gave the. Yeah, that's I double checked me, but that's pretty sure that's right. Subsection F, the AG shall provide guidance to controllers and processors for compliance with the terms of the Vermont Data Privacy Act. Any processor or controller that, in the opinion of the AG, materially complies with the guidance provided by the AG shall not constitute an unfair and deceptive act in commerce. So again, this is also pretty important that, you know, the AG is given pretty big authority here that if they think that a violation, a controller processor could violate the law, but if the AG, in their opinion, believes that, you know, our guidance, they followed our guidance, then it would take them out of the Consumer Protection Act as far as the rights to the AG afforded under that act. Again, consumers don't have the path.
But at that point, if they adjusted their guidance because of what they found, and then they should then know that they have to do it different way.
I would be curious to hear what the AG thinks about this paragraph. They may think this makes sense. I think your question is a good one as far as they produce guidance, and is it at the time the guidance is published that, what about before the guidance? If they were in violation before then? And
Well, I mean, even if they're following the guidance, then the AG then determines, well, wait a minute, we made a mistake, and reissues the guidance.
Right.
That seems to me that the controller then would have to change, or the processors would have to change their way of. They would have to follow the new guidance, not the old guidance.
right. Yeah, and I think if you're going to give the AG the authority to give this guidance, I think you want to be a bit more prescriptive on what this is, because you can adopt rules, right? The AG can adopt rules. There's a process for that, and the legislature is involved in the process. This is just the AG's sole decision that this is our guidance, right? And there's not much here as to what that guidance looks like and what you want them to consider, in that guidance. So yeah, I think it's something to talk to the AG about, and maybe hear some witnesses about how this might look. Okay, any questions about enforcement? 2426, the consumer health data privacy, similar to 208, but it's longer because their exemptions are listed here instead of earlier in the bill. And you'll see some duplicate exemptions as well. No person, so except as provided in subsections B and C of the section, and in 2417, which is the exemptions earlier in the bill, no person shall provide any employee or contractor with access to consumer health data unless the employee or contractor is subject to a contractual or statutory duty of confidentiality. Provide any processor with access to consumer health data unless the person and processor comply with section 2421. 3, use a geofence to establish a virtual boundary that is within 750 feet of any healthcare facility, including any mental health facility or reproductive or sexual health facility, for the purpose of identifying, tracking, and collecting data from, or sending any notification to a consumer regarding the consumer's health data. Or sell or offer to sell consumer health data without first obtaining the consumer's consent. Notwithstanding section 2416, which is the applicability. Yeah, applicability. And other provisions except for this one, other sections except for this one, concerning the consumer health data and consumer health data controllers apply to persons that conduct business in the state, should be capitalized, and persons that produce products or services that are targeted to residents of the state. Subsection C, subsection A of the section shall not apply to any body, authority, board, bureau, commission, district, or agency of the state, or any political subdivision of the state. Person who has entered into a contract with an entity described in subdivision 1 to process consumer health data on behalf of the entity. Institution of higher education, National Securities Association that is registered under 15 USC 70. That must be correct unless I got it wrong twice. 70-0-3 of the Securities Exchange Act of 1934.
It's the same in the Connecticut bill, right? You're fine.
Okay, that must be.
As-
Hopefully they got it right.
No, it literally is on the website.
Financial institution or data subject to Title V of Graham Leach Bliley, covered entity or business associate, tribal nation, government organization, air carrier. So again, these are exemptions from the consumer health data portion. A lot of these exemptions are not explicitly in 208. So something else, again, we can talk about later, but these are important. Okay, and then the effective date is July 1st, 2026. Same thing as H208, but remember H208 had that the study from the AG's office requiring the AG to produce guidance to not just controllers, but also consumers. So consumers are aware what their rights are under the new act. The AG could still do it under S71, but it's not required by law. There's also the applicability decreasing in H208. Eventually gets to what the thresholds are. Actually, I'm sorry, it works backwards. Thresholds reduce in 208. They stay at 100,000 and 25,000 in S71. So you can discuss if you want to lower that, you could, or keep it the same.
We caught this earlier, H32, you're referring on line 16 to July 1st, 2020.
Oh yeah, you were outside. I caught that.
Yeah.
Yeah. There's a couple of those that need to be. Yep.
Michael?
So this is language that's taken from Connecticut that's already in force, correct?
Right.
Both schools are. Both schools are.
Yeah, I mean, Brett Priestley makes the point that H208, they're similar bills, but I think the 208 tries to obviously fix what are seen to be loopholes. I can't say that, but improve it. And certain people would argue, but in some ways it makes it obviously you're including more businesses, right? And you're making yeah.
The question. Is this Connecticut, is it Connecticut? Original Connecticut with improvements that Connecticut's made up to January 1 of this year?
So there are some I'll have to double check with that, but I don't believe biometric data was initially included and they added it recently. And this bill 71 includes the biometric data. But you'll notice 208 is more specific on what it includes, fingerprints, facial scans. This one doesn't say that. It may include it, but it doesn't spell it out, right? So I think there's several things that are, and maybe Rep. Priestley can speak to this, but I think several things are moving in Connecticut that H208 has introduced in that version that may not have been adopted yet, and which may not be adopted, right?
I think it's a wrap for today.